The Constitutional Court has reserved judgment on the constitutionality of the Copyright Act, which makes it near impossible for the visually impaired to access books and reading material. The case was brought by the Blind SA following a High Court victory declaring the Act invalid. A bill to amend the Act has been suspended by Parliament. Activists, including blind and visually impaired people, marched on the Constitutional Court today to fight the hashtag End the Book Famine for the Blind. Let's discuss this further with Demichelle Pitherbridge, who is a Section 27 attorney and joins us virtually from here in Johannesburg. Demichelle, thank you so much for your time this evening. When I saw that I was going to be speaking to you this evening, I thought to myself, are they still fighting this fight? Because this has been going on for quite some time now. Just to give us a foundation for this conversation, talk us through, in short terms, where we are right now, where this all started, and what do we need to happen next.
All right, so, I mean, as you mentioned, the way the Copyright Act is framed at the moment, it puts really serious obstacles in front of persons who are blind or visually impaired if they want to convert a book into an accessible format like Braille or large print. At the moment, it says that anyone who wants to do this needs to get permission from the copyright holder, which can be the author, but sometimes they sell these rights. And this may sound like an easy thing to do, but the truth is it's difficult to track down who these individuals are. This is not public information. And once you do track down these individuals, you have to ask permission to convert the text into an accessible format, and often these requests go ignored or are refused. And if a person who is blind or visually impaired decides to continue in any event, they actually end up committing an offence in terms of the Copyright Act. And it's so severe that they could be held liable for a fine under 5,000 Rand or 3 years imprisonment, and that's just for the first offence. Anything after that is just under 5,000 Rand and under 5 years imprisonment. So it actually criminalizes anyone that is stuck in this position. So that's where we're at the moment with the Copyright Act.
And what is your response to the decision to reserve a final decision from the Constitutional Court? Are you hopeful that it will be a positive outcome for you?
Yes, we're very hopeful. We believe that the court will hold in our favor. We think that the violation is very clear here, that it affects a number of rights: the right to equality, the right to education, the right to participate in cultural life. And so we feel that it's clear-cut and that the court needs to step in and help us advance the rights of this marginalized community.
Now, the Copyright Amendment Bill was introduced in 2015, but 7 years later, the bill remains unresolved. You know, I thought 7 years is almost an entire schooling career of a child that is possibly blind or visually impaired. And it means that there would have been certain books that they wouldn't have been able to discover or to use for their education. That's a long time for this to be hanging in the air. What has been the major hold-up? Because the respondents in the case is the Minister of Trade and Industry and Competition, Minister of International Relations and Cooperation, the Speaker of the National Assembly, the Chairperson of the National Council of Provinces, and the President, and they're not opposing the case. What has been the hold-up for this amendment bill?
Yeah, it's just as you say, that the bill had come out in 2015, and it's been through numerous processes of public consultations in the first House of Parliament. It's been to the NCOP. And even though it was published for comment in 2015, it only went to the President in March 2019. He took a further 14 months before he came out and said, look, this is the concerns he has. He sent it back to Parliament to work through this, and that's where we're at the moment. It's now back at the National Assembly, and just as you say, it's been just under 7 years. It's really difficult to say why there are these delays. Yes, we acknowledge that there have been developments, but one wonders if this is a lack of political will, if it's a lack of prioritization, considering the kind of violations that are taking place. So this is really one of the reasons why we went to court. We have this exception in the Copyright Amendment Bill, which is really not being opposed very much. And we want this to start taking effect while Parliament is sorting out the rest of this process. So this was really the heart of the matter, that this part that will help persons who are blind or visually impaired bypass asking permission, that they implement this now. And that's what we're asking the court to order on while Parliament is busy with this process, because right now there's really no evidence on when it's going to be finalised.
I mean, this is an apartheid-era law that you're trying desperately to change. What is the international best practice when it comes to the legalese around getting books done in Braille?
So this is evidence that we had put forward in our papers as well. This exception that we're asking for that exists in our copyright amendment bill is actually something that's being consented to globally in many countries. The evidence we've put forward is really just proof that 79 countries worldwide have already got this kind of exception already, which are allowing persons to bypass asking permission from the copyrights holder, that are allowing cross-border exchange of books, the importation and exportation of books. So it's really, it's something that's gained a lot of momentum over the last couple of years. It's a practice that's endorsed, and that's really what we're hoping the Constitutional Court will see, that we're not trying to do anything strange here. Yeah. It's really just moving with the trends we see internationally.
And I suppose if, at the risk of sounding flippant, if we had more people in Parliament who either are blind or visually impaired, or had family members or loved ones who were affected, perhaps it would be higher up on the agenda. Talk to me about some of the stories you're hearing from those who are blind and visually impaired about how this has impacted their lives.
So we have really powerful statements in our papers, one particularly from a school teacher that's teaching in the Free State, where he says that even though he's a teacher in a special needs school, which is well resourced, he's a teacher at a school, one of the few schools that is well resourced, and even they struggle to get textbooks for all the subjects. And this is particularly devastating with subjects like maths or science. So we see that it's a problem at a school level. We have a very interesting affidavit by Mr. Lowe, who speaks about his time at university, where he was trying to study, and he was doing research on work that needed textbooks containing mathematical equations, which was very difficult to get in an accessible format. He would have to rely on volunteers who would read the works to him, and often he would only get materials in an accessible format way after the lecture had been given and very close to exams. We also have a very powerful statement by Justice Yaqub, who you may know was a Constitutional Court judge some years back, who gives testimony of how the severe lack of reading materials has really placed him in a worse off position. And even he himself, who has the resources now to do this, that it's been a struggle career-wise and especially in his earlier years. So there's really a lot of evidence this is affecting people in their day-to-day life, and it's something that disempowers this already marginalized community.